On April 15, 2026, the Supreme Court delivered a unanimous ruling that transformed firearm regulations across all 50 states. In Martinez v. New Jersey, all 9 justices agreed the Second Amendment protection to keep and bear arms also covers the right to possess a loaded firearm inside a vehicle for self-defense. The decision invalidated laws in at least 12 states that either banned loaded firearms inside vehicles, demanded separate vehicle permits, or classified vehicles as sensitive places under firearm restrictions. Justice Clarence Thomas, writing for the unanimous court, stated that vehicles qualify as protected curtilage under the Second Amendment. The ruling struck down a New Jersey statute that made it a third-degree crime to transport a loaded handgun in a vehicle, even for someone holding a valid carry permit, unless the firearm remained locked in the trunk with ammunition stored separately. The decision carries nationwide impact because it establishes that states cannot treat vehicles differently from homes when applying Second Amendment protections. Kevin Martinez, a resident of New Jersey, possessed a valid carry permit issued after the Bruin ruling. He was driving home from a shooting range when police stopped him because of a broken taillight. During the stop, the officer asked whether weapons were inside the vehicle. Martinez informed the officer he had an unloaded Glock 19 secured in a locked glove compartment, while ammunition remained inside a separate magazine stored in the center console. Police arrested Martinez under a New Jersey law that prohibited loaded firearms inside vehicles. The statute required guns to remain unloaded, locked inside the trunk, and separated from ammunition, even when the owner held a carry permit. Martinez faced charges classified as a third-degree crime, carrying a possible sentence of up to 5 years in prison. The Third Circuit upheld the conviction, arguing that vehicles do not receive the same constitutional status as homes, and that the state possesses broader authority to regulate firearms inside vehicles. The Supreme Court reversed that decision unanimously. The court held that the Second Amendment protection recognized in Heller during 2008 for the home, and later expanded in Bruin during 2022 for public carry, also applies to vehicles. According to the ruling, vehicles represent constitutionally protected spaces where individuals maintain the right to keep a loaded firearm available for self-defense. States may no longer impose blanket bans on loaded firearms inside vehicles. They also cannot require trunk storage, separation of ammunition, or additional vehicle permits beyond standard carry permits. Justice Thomas wrote that the right to keep and bear arms necessarily includes access to a functioning firearm for immediate self-defense in locations Americans regularly occupy. He stated that vehicles are essential parts of everyday life, where citizens spend significant time and may encounter threats. The opinion further declared that a firearm locked inside a trunk, unloaded and separated from ammunition, offers no practical self-defense value compared to having no firearm at all. The court concluded such requirements destroy the core Second Amendment protection recognized in both Heller and Bruin. The ruling achieved a 9-0 outcome because even the liberal justices concluded the logic followed directly from existing precedents. If the Second Amendment protects a functional firearm inside the home under Heller, and also protects carrying firearms in public under Bruin, the court reasoned it must also protect firearms inside vehicles, which exist between private homes and public spaces. The justices concluded there was no consistent constitutional distinction allowing states to prohibit functional firearms inside vehicles while simultaneously protecting them inside homes and public settings. The ruling immediately affects laws in New Jersey, New York, Massachusetts, Rhode Island, and Connecticut. Those states previously required firearms inside vehicles to remain unloaded, locked in trunks, and separated from ammunition, even for permit holders. Martinez invalidates those requirements. Permit holders may now keep loaded firearms inside vehicles in whatever position allows immediate access. That includes a glove compartment, center console, or holster. California previously enforced Penal Code 25610, which required handguns to remain unloaded and secured inside a trunk. Under Martinez, those restrictions no longer apply to permit holders. Illinois, Maryland, and Hawaii also maintained separate vehicle firearm rules. Illinois demanded both a FOID card and an additional transport permit for vehicles. Maryland separated wear and carry permits from vehicle authorization rules. Hawaii required firearms to stay unloaded inside locked containers regardless of permit status. Martinez removes those independent vehicle transport requirements. Several local governments in Oregon, Washington, and Minnesota had city or county regulations banning loaded firearms inside vehicles. The Martinez ruling overrides those ordinances under the Second Amendment. Certain restrictions still remain constitutional. States may continue requiring non-permit holders to transport firearms unloaded and secured. They may also require firearms left inside unattended vehicles to remain locked in order to reduce theft risks. States can still ban firearms in locations considered genuinely sensitive, including school zones and courthouse parking areas. However, they can no longer classify the personal vehicles of permit holders as gun-free zones. Justice Thomas examined historical tradition in the court's analysis. According to the opinion, Americans during the founding era commonly traveled with loaded firearms in wagons, carriages, and saddlebags. No historical practice required travelers to unload weapons or disarm while moving from place to place. Early state laws regulated carrying firearms in some public locations, but not inside methods of transportation. Restrictions. Targeting loaded firearms inside vehicles first appeared during the middle of the 20th century, roughly 175 years after ratification of the Second Amendment. The court determined those modern laws lacked any founding era equivalent and therefore failed the historical tradition standard established in Bruin. The opinion also compared vehicles to the protected area surrounding a home, often described as curtilage, which receives both Fourth Amendment and Second Amendment protection. The court noted that Americans spend major portions of their lives inside vehicles, where they may face threats including carjacking, road rage incidents, or roadside breakdowns. Because of that, citizens maintain a legitimate interest in having a functional firearm available for self-defense. The ruling also changes how traffic stops involving firearms are handled. Police officers may no longer justify a vehicle search solely because a firearm is present. Martinez reinforces that a legally possessed firearm inside a vehicle does not automatically establish probable cause. If an officer observes a firearm and the individual possesses a valid permit, the officer cannot search the vehicle based only on the weapon's presence. Duty to inform statutes still remain active. Ohio, Louisiana, Texas, North Carolina, Alaska, Arkansas, Michigan, Nebraska, and other states still require permit holders to notify officers during encounters. However, once notification occurs, officers cannot arrest permit holders simply because they possess a loaded firearm inside a vehicle. Officers still retain authority to secure weapons temporarily during a stop for safety reasons. Pennsylvania v. Mims permits officers to order occupants out of a vehicle. Terry authorizes a protective pat-down when reasonable suspicion exists. Under those precedents, officers may temporarily hold firearms during a traffic stop, but must return them once the stop ends if no arrest takes place. Several actions are no longer treated as criminal conduct for permit holders. A loaded firearm inside a glove compartment, center console, or door pocket now falls under constitutional protection. Ammunition may remain in the same container as the firearm. A loaded magazine inserted into the firearm is also protected. Driving with a firearm available for self-defense now receives constitutional protection for permit holders. Some regulations still survive. States may continue banning firearms inside school zones under the Gun-Free School Zones Act. They may also require guns inside unattended vehicles to remain locked in order to prevent theft. Parking restrictions near courthouses and government buildings may still be enforced. The ruling also changes what firearm owners should do moving forward. Gun owners should review state laws to determine whether prior restrictions existed. Martinez invalidates rules requiring unloaded transport, separation of ammunition, trunk storage, and additional vehicle permits. Permit holders are encouraged to contact state attorneys general to confirm how implementation will proceed. Individuals who previously transported firearms unloaded inside trunks may now keep loaded firearms within reach, including inside glove compartments, center consoles, or holsters. The court emphasized balancing accessibility for self-defense with protection against theft or unauthorized access. In states with duty to inform laws, permit holders should notify officers immediately during traffic stops. During a traffic stop, permit holders are advised to immediately inform the officer about both the carry permit and the firearm inside the vehicle. A typical notification could be direct and simple. Officer, I have a valid carry permit and a loaded firearm secured in my glove compartment or center console. How would you like me to proceed? Drivers should then follow all instructions given by the officer. If law enforcement temporarily takes possession of the firearm during the stop, the individual should remain calm and cooperate fully. If an officer attempts to arrest a permit holder for possessing a loaded firearm inside a vehicle after the Martinez ruling, the individual should still comply peacefully while carefully documenting every detail afterward and contacting an attorney. According to the ruling, such an arrest violates constitutional protections. The Martinez decision applies specifically to permit holders. Individuals without carry permits may still remain subject to previous transportation requirements, including unloaded firearms and locked storage containers. Obtaining a valid permit remains necessary for exercising full vehicle carry rights. States may also continue requiring firearms to be secured whenever a vehicle is left unattended in order to prevent theft. Owners should lock firearms inside a trunk, glove compartment, or center console before leaving the vehicle. Travel between states still requires caution. Martinez establishes a federal constitutional baseline, but reciprocity rules continue varying from state to state. Before traveling, permit holders should verify whether the destination state recognizes their permit. The Federal Firearm Owners Protection Act also provides limited safeguards for transporting firearms through different states. If state authorities continue enforcing restrictions invalidated by Martinez, firearm owners are advised to document everything carefully. Important details include the officer's name, badge number, and all arrest information. Individuals may also contact Second Amendment organizations that could pursue legal action to enforce the Martinez ruling. State officials who continue enforcing unconstitutional laws may face federal civil rights liability. The Martinez versus New Jersey decision, delivered unanimously by a 9-0 vote, fundamentally reshaped vehicle firearm laws across the nation. The court's central holding declared that the Second Amendment right to keep and bear arms extends into vehicles. Vehicles now qualify as constitutionally protected spaces where individuals may possess loaded and functional firearms for self-defense. Justice Clarence Thomas wrote for the unanimous court that the constitutional guarantee to keep and bear arms necessarily includes the ability to possess a functional firearm inside a vehicle. The ruling reached a unanimous outcome because even liberal justices concluded the reasoning followed directly from Heller and Bruin. If firearms receive constitutional protection inside homes under Heller and in public carry situations under Bruin, the court determined there is no logical constitutional distinction permitting states to ban them inside vehicles which exist between private homes and public spaces. The decision struck down restrictions in New Jersey, New York, Massachusetts, Rhode Island, Connecticut, California, Illinois, Maryland, Hawaii, and Michigan. Those laws had required firearms inside vehicles to remain unloaded, locked in trunks, separated from ammunition, or regulated through additional vehicle permits. Martinez invalidated those requirements for permit holders. The court's historical analysis emphasized that Americans during the founding era routinely traveled with loaded firearms in wagons, carriages, and saddlebags. No founding era laws required travelers to unload weapons or separate ammunition during transportation. Vehicle firearm restrictions first appeared during the middle of the 20th century, approximately 175 years after ratification of the Second Amendment. The court concluded those laws failed the historical tradition and standard established under Bruin. The ruling also compared vehicles to constitutionally protected curtilage. The court confirmed that officers may not search vehicles solely because a firearm is present. Duty to inform statutes remain valid. Officers may temporarily secure firearms during traffic stops, but they must return them once the stop concludes if no arrest occurs. Several activities are no longer criminal for permit holders. A loaded firearm inside a glove compartment or center console is constitutionally protected. Ammunition may remain stored in the same container. A loaded magazine inserted into the firearm also falls under constitutional protection. Driving with a firearm available for self-defense is now protected for permit holders nationwide. Gun owners are encouraged to review current state laws, adjust how firearms are carried inside vehicles, understand traffic stop procedures, comply with officer instructions, and secure firearms whenever vehicles are unattended. Non-permit holders remain restricted under state law, making valid permits necessary for full protection under Martinez. Individuals traveling across state lines should continue checking reciprocity agreements and reviewing employer parking lot policies before carrying firearms into restricted areas. Martinez versus New Jersey now stands as one of the most significant expansions of Second Amendment vehicle carry protections in American history. All 50 states must now allow permit holders to keep loaded and functional firearms inside vehicles. The Supreme Court's 9-0 decision permanently changed firearm law across the United States. If you want more updates on major Supreme Court rulings, constitutional rights, and nationwide legal changes, stay connected for future reports. Please leave your thoughts about this content in the comments below. Thanks for watching. See you in the next one.